And Mr. Cole, you're recognized.
Thank you very much, Mr. Chairman, Mr. Ranking Member. I really appreciate you holding this hearing today on what I think is an exceptionally important topic. I'll have prepared remarks that are going to be submitted later today. I appreciate the committee's indulgence and cooperation in that. It's been very, very helpful. And I'm here in my capacity, and I think my good friend Ms. McCollum's here in her capacity as co-chairman of the Native American Caucus to express our concerns and opinions about the Indian Recognition Act of 1934. Just to be clear up front, we oppose any repeal or significant modification of the Indian Recognition Act 1934. We would favor strengthening the Secretary's authority to put land into trust. We believe the obvious fix for that is legislation that Ms. McCollum has a bill, I have a bill, we actually co-sponsor one another's bill. We think either of them would be an appropriate vehicle to resolve this thorny dilemma. We approach this with the traditional view of the nature of the relationship between Native American nations and the United States government. While we recognize states and localities may have views and interests and they ought to be taken into consideration, the Constitution, the law, and jurisprudence is awfully clear that the relationship with Indian nations is solely the province of the federal government. Other people don't have any authority here. They can express a view, but they shouldn't have any formal role in the process of recognition. The purpose of the Indian Regulatory Act was to stop the erosion of the tribal land mass, which had been going on over the preceding half century. From 1887 to 1934, the Indian land mass shrank from 138 million acres to 48 million acres. And the Dawes Act and the allotment process that spearheaded that was opposed by every single Indian tribe. This is not a policy that was advocated by Indians for Indians. This was a policy that Indians at the time violently opposed, and because they understood what the consequences were going to be. Just as most tribes, frankly every tribe I know, would oppose any effort to repeal or significantly modify the Indian Recognition Act. The Indian Recognition Act has actually done what it was supposed to do. It stopped that erosion at 48 million. We've modestly grown the land base back to 56 million acres or so, and in an appropriate, thoughtful, step-by-step way, secretaries of both parties and all administrations until the Carcieri decision looked at these decisions and I think made the appropriate decision. By way of historical background, I had the opportunity to read the background statement, and I want to take issue, and I want to do this very respectfully, with a couple of things, just to inform the committee of at least the way I personally look on this issue. It says in the document, allotment had a humane basis. Congress and activists wanted to convert impoverished Indians living on tribal communal property into property-owning farmers and ranchers who would presumably assimilate in the Western economy. The act failed because many Indians did not adjust or were not taught to adjust to the radical shift in their culture, economy, and lifestyle. That's just not true. That is a misstatement of historical reality. And I know this firsthand because my family went through this process. So the record is awfully clear, and I would commend to the committee, if you want to understand at least what happened in Oklahoma, there's a wonderful book by Angie DeBow called And Still the Waters Run, which is the classic treatment of this, and it makes it awfully evident. The Indians in Oklahoma were neither impoverished nor backward. They were actually more progressive. They had their own governments, their own written languages, their own territory. They were all opposed to what happened to them. And the Dawes Commission was an egregious violation of every treaty that the United States had signed. The Indian Reorganization Act was an effort to reverse that awful and tragic mistake. And let me end up and be very personal here. My great-great-grandfather, when he was 14 years old, walked 800 miles to Indian Territory, became the chief clerk of the Supreme Court of the Chickasaw Supreme Court before there was a territory of Oklahoma. His son, my great-grandfather, became the treasurer of the nation before there was a state of Oklahoma. And my great-grandfather, involved in the allotment process, the decisions that had to be made in terms of trying to preserve what could be saved. And my grandparents went through this process. What happened was my brother and I owned the last of our allotment land. But what happened on ground, whatever the intentions of a few idealistic reformers in Washington, was the systematic stripping away of land from individuals. I'll give you two personal examples. My grandmother and my great-grandfather always warned her, don't marry a white man. Probably pretty good advice in the early part of the 20th century. She ignored that. One of her sisters ignored that. In the case of my grandmother, married a guy, he immediately sold the land, immediately divorced her, and gone. The other one just didn't bother with the divorce, he just disappeared. And that happened case after case after case. That is why the Congress of the United States intervened appropriately in 1934 to stop this from happening. And it happened all over Indian country to all kinds of tribes. So as you approach this, I would hope that we do what we did not do in 1887. We actually listened to tribal nations. Usually Indians know what's best for Indians, and they have repeatedly told us this was not the way to go then. Don't reverse this now. And again, they're awfully united in asking that either Ms. McCollum's bill or my bill or some combination of the two be advanced so that the ability of the Secretary, judiciously used to put land into trust, will be strengthened and recognized again. Right now, the Secretary, whoever that individual is, has the unenviable task of frankly trying to administer between two different kinds of Indian tribes. One that they can put land into trust for, another group that they cannot. That simply creates a group of second-class Indian tribes. Not the intent. It's a bad judicial decision by the Supreme Court, with all due respect to the body, ought to be reversed. But anyway, the position of our caucus is very strongly in defense of the Indian Recognition Act and the appropriate modification with a Carcieri fix. So thank you for your indulgence, Mr. Chairman, and thank you for holding a hearing on this really important topic.
Thank you, Mr. Cole, and thank you for your knowledge of this issue. As time goes